Part 1. The crime that shook Britain. A quiet market town. 3 teenage boys, 2 young victims, and a court decision that would leave an entire nation asking whether justice had failed. When the Court of Appeal later ruled that the original sentences were too lenient, headlines across Britain focused on one question above all others. How could boys convicted of such serious crimes have avoided immediate custody in the first place? To understand why the country became so divided, we have to go back to where the case began. The setting was Fordingbridge, a small town in Hampshire on the edge of the New Forest. It is the kind of place where neighbours know each other, children often grow up together, and violent crime rarely dominates national news. But beneath that peaceful image, a criminal investigation was quietly unfolding, one that would eventually expose a series of offences involving children on both sides of the courtroom. For legal reasons, the identities of the victims and the offenders remain protected. What has been made public through court proceedings, however, reveals a deeply disturbing sequence of events. The victims were both girls under the age of 16. The offenders were boys between 13 and 15 years old. According to prosecutors, the attacks occurred during separate incidents in late 2024 and early 2025. Although they happened at different times, investigators soon discovered connections between those involved. The girls knew the boys. This was not a case involving strangers hiding in the shadows. Instead, prosecutors argued that trust and familiarity had placed the victims in situations where they became vulnerable. One incident took place in a secluded pedestrian underpass. Another happened in an isolated field away from public view. Police have never released every detail of what occurred, both to protect the victims and because of strict reporting restrictions surrounding juvenile offenders. But what investigators uncovered was enough to trigger one of the most significant youth criminal cases Britain had seen in recent years. The investigation began after one of the victims reported what had happened. Officers from Hampshire police immediately recognised the seriousness of the allegations. Specially trained investigators interviewed the victims using procedures designed for vulnerable witnesses. Every statement was carefully documented. Every timeline was checked. Every possible piece of evidence was pursued. As detectives began examining mobile phones belonging to those involved, the investigation took an even more disturbing turn. Digital forensic specialists recovered material that prosecutors later described as crucial evidence. Among the files examined was video footage connected to one of the offences. Rather than relying solely on witness testimony, investigators were able to compare digital evidence with phone records, location data, messages, and interviews. Each new discovery helped detectives reconstruct what had happened with increasing accuracy. Investigators also interviewed numerous witnesses who had interacted with either the victims or the suspects before and after the incidents. Their statements helped establish movements, conversations, and the sequence of events that prosecutors would later present in court. By this stage, detectives believed they had assembled a clear evidential picture. The Crown Prosecution Service reviewed the material collected by police. After considering the evidence, prosecutors authorised multiple serious charges against 3 boys. Because all of the defendants were under the age of 18, the case proceeded through the youth justice system, where reporting restrictions prevented the publication of names or identifying details. That legal protection exists for an important reason. British law recognises that children who enter the criminal justice system deserve a degree of anonymity even when accused or convicted of extremely serious offences. At the same time, those same protections often make cases like this difficult for the public to fully understand. Much of what happened inside the courtroom could only be reported in limited detail. Nevertheless, the evidence that did emerge painted a deeply troubling picture. Prosecutors argued that the offences were not isolated acts of poor judgment. Instead, they described conduct involving multiple offenders, vulnerable victims, and lasting psychological consequences. The victims later explained how their lives had changed after the attacks. Activities that once felt ordinary became sources of anxiety. Confidence disappeared. Relationships became strained. The sense of safety they had once enjoyed within their own community had been replaced by fear. For investigators, these victim impact statements were an important reminder that criminal cases do not end when evidence is collected. Long after police complete their work, victims continue living with the consequences. As the trial progressed, the courtroom heard evidence from investigators, forensic specialists, and expert witnesses. Digital material recovered from electronic devices was carefully examined. Witness accounts were tested through cross-examination. Each side presented its arguments before the judge reached a verdict. After hearing the evidence, the court found the 3 boys guilty. For the victims and their families, the convictions represented an important moment. Their accounts had been believed. The evidence had been accepted. Responsibility had been established. Many assumed the next stage would be straightforward. Given the seriousness of the offences, immediate detention appeared likely to many legal observers and members of the public. Instead, what happened at the sentencing hearing shocked even experienced court reporters. Rather than imposing custodial sentences, the judge chose youth rehabilitation orders, sentences focused on supervision, education and rehabilitation within the community. Within hours, newspapers across Britain were carrying the story. Victims' advocates questioned whether the punishment reflected the gravity of the crimes. Legal experts debated whether the court had correctly balanced rehabilitation against accountability. Across television, radio, and social media, one question dominated the national conversation. Had the youth justice system protected the offenders more than the victims? The controversy grew so quickly that it would soon reach Britain's highest criminal court. What followed was an extraordinary legal battle that would force the country to confront one of the most difficult questions in modern justice. When children commit exceptionally serious crimes, where should society draw the line between rehabilitation and punishment? That question would soon be answered, not by the original trial judge, but by the Court of Appeal. When the verdicts were announced, many people believed the most difficult part of the case was over. The 3 boys had been found guilty. The victims had endured the emotional strain of the investigation and the court proceedings. Their families hoped the sentencing hearing would finally bring a sense of justice. Instead, it marked the beginning of an entirely new controversy. The trial judge decided that none of the 3 teenagers should be sent immediately to custody. Instead, they received youth rehabilitation orders, a sentence designed to supervise young offenders within the community while focusing on education, behavioural intervention, and rehabilitation. For many members of the public, the decision was almost impossible to understand. How could offenders convicted of such serious sexual crimes avoid detention? The answer lies in one of the most distinctive features of England's youth justice system. Unlike adult courts, youth courts are required to treat custody as a last resort. Judges must balance punishment with the possibility that a young offender can still change. The court considered several factors before reaching its decision. The boys were between 13 and 15 years old when the offences occurred. Psychological assessments suggested varying levels of emotional maturity. The judge also considered their family backgrounds, educational needs, and the long-term impact that detention might have on children still developing mentally and emotionally. In the judge's view, rehabilitation offered a better chance of preventing future offending than immediate imprisonment. Legally, that reasoning was consistent with the principles of the youth justice system. But outside the courtroom, the public reaction was immediate and fierce. News organisations across the United Kingdom questioned whether the sentences reflected the seriousness of the crimes. Victim advocacy groups argued that the punishment failed to acknowledge the lasting psychological harm suffered by the girls. Legal commentators pointed out that while rehabilitation is an essential principle, public confidence in the justice system depends on sentences being proportionate to the gravity of the offence. Social media quickly amplified the debate. Thousands of people questioned whether the justice system had become too lenient. Others defended the principle that children, even those convicted of serious crimes, should not automatically be treated as adults. The country appeared deeply divided. Then the controversy reached the attention of the Attorney General's office. Under a little-known legal mechanism called the unduly lenient sentence scheme, certain criminal sentences can be referred to the Court of Appeal if there is reason to believe they are significantly too lenient. The scheme is rarely used in youth cases, but this case was different. After reviewing the facts, the Attorney General referred the sentences to the Court of Appeal, arguing that the original punishment might not adequately reflect the seriousness of the offences. It was an extraordinary step. Instead of the victims appealing the convictions, the government itself was effectively asking senior judges to decide whether justice had been done. The decision immediately placed the case under national scrutiny. Legal experts began analysing previous sentencing decisions involving juvenile offenders. Newspapers revisited the details of the assaults. Television debates asked the same difficult question night after night. Where should society draw the line between protecting young offenders and delivering justice to victims? Supporters of the original sentences warned against abandoning the principles of youth rehabilitation because of public anger. Critics argued that some crimes are so serious that age alone cannot outweigh accountability. As the debate intensified, Britain's most senior judges prepared to examine every aspect of the case. Their decision would not only affect the three boys, it could also shape public confidence in how the justice system handles some of the country's most serious crimes committed by children. When the Court of Appeal finally delivered its judgment, it became clear that the original sentencing decision would not stand. The country's highest criminal court had reached a very different conclusion. As public anger continued to grow, Britain's legal system faced an extraordinary test. This was no longer just a case about three teenage offenders. It had become a national debate over one fundamental question. Can a sentence be lawful and still fail to deliver justice? The mounting criticism eventually reached the Attorney General's office, which has the authority to review certain criminal sentences under the unduly lenient sentence scheme. The scheme exists for exceptional cases, allowing the government to ask the Court of Appeal to reconsider a sentence if it appears significantly too lenient. Youth cases are only rarely referred, but after reviewing the circumstances of this case, the Attorney General concluded that it deserved further examination. The matter was sent to the Court of Appeal, where three senior judges would decide whether the original sentencing judge had made a legal error in exercising discretion. The hearing attracted intense media attention. Victims' rights organisations, legal commentators, and members of the public closely followed the proceedings, aware that the outcome could influence how future cases involving serious crimes committed by children would be handled. The Court of Appeal did not rehear the evidence of the offences. The boys' convictions were never in dispute. Instead, the judges focused on a single issue. Were the original sentences unduly lenient? Government lawyers argued that the sentencing judge had placed too much emphasis on rehabilitation and insufficient weight on the seriousness of the offences. They pointed to the lasting psychological harm suffered by the victims, the involvement of multiple offenders, and the need for sentences that reflected both accountability and public confidence in the justice system. Lawyers representing the boys defended the original decision. They reminded the court that the offenders were only 13 to 15 years old at the time of the crimes. They argued that the youth justice system was deliberately designed to give young offenders an opportunity to reform, and that immediate custody should remain a last resort whenever possible. The judges listened carefully to both sides. Then came the decision. Delivering the judgment, the Court of Appeal concluded that the original sentences had failed to reflect the exceptional seriousness of the offences. While acknowledging that rehabilitation remains a central principle of youth justice, the court ruled that this principle could not outweigh the need for punishment in every case. The judges stressed that serious sexual offences causing profound and lasting harm require sentences that properly recognise both the impact on victims and the gravity of the crimes. As a result, two of the boys received substantially increased custodial sentences. They were ordered to serve 4 years of detention in a young offender institution. For the third and youngest offender, however, the court reached a different conclusion. Because of his age at the time of the offences and his more limited role in one of the incidents, the judges decided not to impose immediate detention, although they agreed that the original sentence required adjustment. The ruling represented a significant shift from the original judgment. It also sent a clear message that rehabilitation, while vital, does not automatically outweigh accountability when exceptionally serious crimes are involved. Legal experts quickly described the decision as one of the most important appellate rulings on youth sentencing in recent years. Some welcomed the judgment as restoring public confidence in the justice system. Others warned that it risked moving youth justice closer to an adult model of punishment, potentially weakening the long-standing emphasis on rehabilitation. The debate was far from over. For the victims' families, the increased sentences were an acknowledgement that the original punishment had not reflected the seriousness of what had happened. Yet even after the Court of Appeal's decision, they believed true justice remained out of reach. In emotional interviews following the ruling, the parents explained that no sentence, no matter how long, could undo the lasting damage their daughter had suffered. Their words would become the emotional conclusion to a case that had challenged not only Britain's courts, but also the nation's understanding of justice itself. When the Court of Appeal announced the new sentences, many believed the case had finally reached its conclusion. The original decision had been overturned. 2 of the offenders would now be sent to custody. From a legal perspective, the appeal had succeeded. But for one family, the ruling did not bring the closure they had spent months hoping for. Speaking publicly for the first time since the appeal, the parents of one of the victims gave an emotional interview, choosing to remain anonymous to protect their daughter's identity. They said they welcomed the Court of Appeal's decision, but they also made one thing painfully clear: it is still not enough. For them, the issue was never simply about the number of years in custody. It was about a lifetime that had been permanently altered. They described watching their daughter struggle with fear, anxiety, and the emotional consequences of what had happened. Everyday routines that most families take for granted had become difficult. Simple outings required reassurance. Trust in other people had been shattered. Even after the convictions and the successful appeal, they said the effects of the crimes had not disappeared. "The sentence has an end," one parent explained, "but what our daughter lives with does not." Those words captured a painful reality that many victims' families understand all too well. A prison sentence eventually expires. The emotional impact on victims often does not. The parents also expressed disappointment that the original sentencing decision had forced them to endure another lengthy legal process. Instead of beginning to rebuild their lives after the trial, they found themselves once again following court hearings, media reports, and public debate. Each new development reopened emotional wounds they had hoped were beginning to heal. Their experience also highlighted another difficult aspect of serious criminal cases. While court proceedings eventually come to an end, recovery rarely follows the same timetable. For victims, healing is often measured not in months or years, but in small personal milestones that cannot be imposed by any legal judgment. The case has since become part of a much broader national conversation. Some legal experts argue that Britain's youth justice system remains one of the most progressive in the world because it prioritises rehabilitation and reduces repeat offending among young people. Others believe that exceptionally serious crimes require a stronger emphasis on accountability, regardless of the offender's age. Neither position offers an easy answer. Protecting children from becoming lifelong offenders is an important goal. So is ensuring that victims feel the justice system recognises the seriousness of what they have endured. The Court of Appeal attempted to balance those competing principles. Whether it succeeded remains a matter of public debate. What is beyond dispute is the lasting impact this case has already had. It prompted renewed scrutiny of how serious sexual offences committed by juveniles are sentenced. It demonstrated that appellate courts are prepared to intervene when they believe a sentence fails to reflect the gravity of the offence. And perhaps most importantly, it reminded the public that behind every headline, every legal argument, and every court ruling is a victim whose life has been permanently changed. For the anonymous parents who chose to speak, their message was never driven by revenge. It was about recognition. Recognition that serious crimes leave lifelong consequences. Recognition that victims deserve to feel heard. And recognition that justice cannot always be measured solely by the length of a sentence. The legal proceedings may now be over. The appeal has been decided. the offenders have received new sentences. But for one family, and for many others who have experienced similar trauma, the journey toward healing continues long after the courtroom falls silent. As Britain reflects on this landmark case, one difficult question remains. Can any sentence truly deliver justice when the harm lasts a lifetime? If you found this case informative, consider subscribing for more in-depth true crime documentaries that examine not only the crimes themselves, but also the investigations, the courtroom decisions, and the difficult questions they leave behind. And we'd like to hear your perspective. Do you believe the Court of Appeal reached the right decision, or should the original sentences have been left unchanged? Share your thoughts respectfully in the comments below.